Welcome colleagues. Openciencia continuously carries out international events inviting experts to share their knowledge and experience to researchers, students, professors, and editorial teams. One of our aims is to train editorial teams improving the editorial work. In turn, the quality of the research products that are published is increased. Today, Openciencia is bringing you the conference titled Issues in Open Access Publishing 2022. It's an annual conference concerning the issues in open access publishing. In this year's event, we are going to address some issues in copyright and licensing that we have observed in scholarly journals in the Latin American region. For instance, missing information concerning the copyright and licensing in manuscripts, the absence of copyright and licensing agreements in some journals, the contradictory terms that we have observed in agreements that we have revised, the conflicting terms in agreements with the copyright law, the use of certain licenses, and many others. Thus, Openciencia has invited renowned experts from around the globe to provide understanding and solutions to these issues. The presenters belong to renowned institutions such as Creative Commons, Swansea University, the National Institute of Authors' Rights from Mexico, and the Intellectual Property Registry of Guatemala. Openciencia is very pleased to have these experts presenting at the event. We welcome them, hoping that their vast knowledge and experience is going to help editorial teams from scholarly journals, making them aware of these issues and clarifying all the questions that we have. We will also like to welcome our attendees today. We have invited colleagues from 3 continents who are related to editorial work and research products. Without them, these events wouldn't make sense. As regards the conference program, let me explain you some important details about it. The first 2 presentations are going to be held in English language, and the last 2 in Spanish. Hence, please select the correct interpretation language in Zoom. We are providing English-Spanish interpretation in the first 2 presentations and Spanish-English interpretations in the last 2. As it happens in all events, we might have certain technical difficulties. We apologize for any inconvenience or delays. Please pay attention to the following instructions. In each presentation, you can type your questions in the chat. Please note that we require you to type the questions in your native language. We are going to translate them to the presenters during the Q&A sessions. Copyright and licensing are relevant to protect the scholarly work and maintain control over how it's used. Our first presenter at the conference is Mónica Granados from Creative Commons. We are very pleased that Creative Commons has been collaborating in the events we organize every year. Mónica is going to present the topic concerning copyright and licensing in open access journals. One of our colleagues from Norway, Marlene Svela, has prepared a video introducing her. Let's proceed to watch the video.
Good morning, colleagues. It's an honor to have renowned colleagues from different institutions around the globe participating in the event titled Issues in Open Access Publishing 2022. Pivovar and others indicated that at least 28% of the scholarly literature around the world are open access. However, Miguel and others mentions that in the Latin American region, the open access scholarly literature reaches to 73.9%. Despite of the popularity of the open access movement, editorial teams of scholarly journals struggle to comply with the open access standards. Aguilera Arevalo pointed out that licensing and copyright ownership is missing in more than half of journals in Mexico and Guatemala. Therefore, Openciencia has invited an expert in open access, Dr. Monica Granados. Dr. Granados is the Open Climate Campaign Manager at Creative Commons, one of the leading non-profit organizations providing open access licenses, mainly used by scholarly journals. Dr. Granados has a bachelor's degree in zoology and a master's degree in ecology and evolutionary biology from the University of Toronto. She also holds a PhD in biology from McGill University. From 2016 to 2018, she carried out a postdoc at University of Guelph and Wildlife Conservation Society Canada. Concerning her experience, Dr. Granados has been a data scientist consultant for various federal departments in Toronto, Canada. In addition, she has been working as a member of the leadership team at Pre-Review, a platform to make peer review more open and diverse. Furthermore, Dr. Granados has been the senior policy advisor in the Communication and Open Sciences section at the Environmental and Climate Change Canada. She is currently on leave from this position to work at Creative Commons to open climate change and biodiversity research. Dr. Granados also has teaching experience, delivering open science and reproducibility, data analysis and visualization, as well as improvisation for science communication workshops. With respect to her achievements as a researcher, Dr. Granados has been awarded 11 grants and fellowships from renowned institutions such as Wellcome Trust, Mitax Canada, the Quebec Centre for Biodiversity Science, among others. She has also written numerous papers concerning open data and environmental science, food, and ecology in renowned journals such as American Naturalist, PLOS, and Facets. Dr. Granados is from Mexico. However, she lived in the United States and Canada and is fluent in English and Spanish. Please welcome Dr. Granados, who is going to present the topic titled Copyright and Licensing in Open Access Journals.
Thank you, Marlene. Please welcome Dr. Granados. Monica, good morning. Can you hear me?
I can. My video is disabled, so
Okay.
you want to switch that on. Okay, apologies for that delay.
No worries.
Thank you so much for that wonderful introduction. I am honored and pleased to be here con todos ustedes para hablar de Creative Commons, and particularly the intersection of open access and licensing, and how those two things together can make it easier for us to share our science, our research, our scholarship. So as you heard, I am Monica Granados. This is a presentation that is built from an existing presentation by Brigitte Vezina, who is the Director of Policy at Creative Commons and one of my colleagues. So why don't we start a little bit first about our mission. So the mission at Creative Commons is to empower individuals and communities around the world by equipping them with technical, legal, and policy solutions to enable sharing of knowledge and culture in the public interest. So as I mentioned earlier, among the many things that Creative Commons does to share to help enable sharing of knowledge is that intersection of Creative Commons and open science. We are strong supporters of open access and open science. And we use our licenses and tools, and they are the global standard for open access publishing. They are free to use and are standard licenses that enable creators to share the content they have created with everyone worldwide on the conditions that they determine, meaning you have some availability of options with how you share your research. We work to ensure that the public is able to access immediately, free of charge, and without restriction, the peer-reviewed publications resulting from academic and scientific research. In line with our strategic goals, our efforts are to focus on, as you see here, driving public policy change, building infrastructure, and guiding institutions in creating, adopting, and implementing open access policies. For example, we've done some guidance on the UKRI consultation on open access policy. We helped with the creation of the UNESCO recommendation on open science, as well as the recommendation on open education. So we like to use the knowledge that we have in our organization to help promote openness, but also to share that expertise with others. So great. It's just doing okay. So let's talk a little bit about publishing models. The traditional model is really unsuitable to the ways in which academic research is funded, conducted, and disseminated. So what does that mean? It means that the way that we are doing science traditionally is not necessarily in the interest of the scientific or the knowledge or scholarly communication process. It raises legal, technical, and financial barriers around knowledge, and perpetuates unbalanced power relationships amongst researchers, research institutions, publishers, libraries, and the general public. Nowadays, with new technologies and the internet, academic knowledge is produced, shared, and built upon at a pace and through methods that call for an approach to publishing that favors access, collaboration, and fairness. Many funders, especially governments and philanthropic foundations, require that research outputs be openly published to guarantee that the public can access, use, and reuse, and build upon the knowledge created. Creative Commons consistently advocates for open access policies on publicly funded research outputs. That is how we can make the science, knowledge, and scholarly outputs more open and more accessible. So what are some advantages to having an open access model? They're really undeniable and increasingly evident across all academic disciplines and scientific research. Making academic publications freely and openly accessible and reusable provides broad visibility for authors, better return on investment for funders, and greater access to knowledge for other researchers and the general public, thereby stimulating knowledge creation and sharing, as well as spurring innovation. So what do we specifically suggest within the open access model? So we've talked about the traditional model and how that is unsustainable and not the best way to make our research available to as many people as possible. But even within the open access model, Creative Commons has some suggestions to make it easier, even within open access, to make it easier to share and remix and reuse science. So specifically, we've got the following recommendations. A zero embargo period, so everyone, everywhere, can read the research fully and immediately and at the moment of publication. A CC BY license on articles to allow for text and data mining at no cost access. And a CC0 license on research data according to FAIR principles to be clear that the data is in the worldwide public domain. We strongly discourage the publication of corresponding software or code under a CC license. Instead, any software or code should be licensed under an OSI-approved free and open source software. And the reason for that is that there isn't specific language in the CC licenses pertaining to software and code. This also means that they're not compatible with some licenses like the MIT and GPL license. So it's more difficult then to combine works if it's licensed under a CC license. So we suggest that you use an OSI approved free and open source software. Okay, so what is CC BY? And is ND not OA? So is a non-derivative OA? So I'm here to say that it's not OA. And here's the reasons why, or at least not to the extent that we recommend. So some researchers choose to publish the research papers under restrictive licenses, under the belief that they are doing so, they are then safeguarding their academic integrity or their works so that it's not used, for other commercial purposes. No derivative licenses, so that's the CC BY ND and CC BY and C and D, allow people to copy and distribute a work, but prohibit them from adapting, remixing, transforming, translating, or updating it in any way that makes a derivative. In short, people are not allowed to create derivative works or adaptations. So it has to stay as is. The use of ND licenses should not be considered as an option for open science, open knowledge, open scholarly communication. These licenses include restrictions on standard reuses that researchers and the general public need in order to maximize the benefit of research outputs, such as adaptations for a different readership or translation in other languages. So the non-derivative licenses make it really difficult to use open science to its most potential. By contrast, CC BY, open access research, can be translated into other languages, adapted for use as open educational resources in the classroom, for example, or shared widely on other platforms that champion the spread of knowledge, such as Wikipedia. Often, the other non-CC BY licenses are also not compatible necessarily with each other. So if you've got work that is NC, or if it's CC BY, with a non-derivative, you won't be able to use that material with other material that is CC BY. So we highly encourage to use this permissive license in the context of open scholarship to maximize, the potential and the reason you want to share your research openly. We also don't want to put technical barriers in the material that we produce as scientists. All research outputs, so that includes article text, images, charts, graphs, data, should be made available in a machine readable form to take advantage of new computational technologies, including text and data mining, machine learning, and AI. Other technical suitable formats that allow for modifications in open standard formats to the highest resolution or quality possible that allow for reusability in any given context. So we don't just want things to be open. We want to make it as easy as possible to use research outputs. So by lowering those barriers, making things machine readable, and using other technically suitable formats, you're going to make it easier to share and reuse research outputs that could then generate new discoveries and new innovations. Open access really is the best way to share science. The COVID-19 crisis has shown that openly sharing research is the best way to do research. How could anyone justify an embargo period on COVID-19 related research articles? We saw that. We saw the potential of open science start to be realized during the COVID-19 crisis when we were sharing our results as quickly as possible, sharing the sequencing of the virus, sharing in a way that we have never seen before in the history of scholarly communication, with the increase in preprints and the increase in publications and the taking down of paywall. So we know that open is incredibly important, not only for all science, but I would say particularly when we have a grand challenge in front of us. We need to have access to information, data, and knowledge that will help us address grand challenges like the COVID-19 crisis. In fact, very recently, the Wellcome Trust just released a report that showed that openly sharing research helped address the COVID-19 crisis. And you could read a little bit more about the work that Creative Commons advocated for during the COVID-19 crisis at this blog written by my colleague, Brigitte. So I mentioned to you that for big challenges that we are facing, we particularly need open science, open knowledge, open scholarship. And what CC is doing is looking at what are other grand challenges that we are facing that we need to concentrate and put our efforts towards as an open community. And so my role at Creative Commons is to work on the Open Climate Campaign. It is the recognition that climate change and the threats to biodiversity are one of the greatest challenges that we are facing as humanity, as publishers, as scientists, and just as people. And so what we're doing with this campaign is over the course of a couple of years, we are going to be working with funders, national governments, and environmental organizations to help spread the word about the importance of making climate change and biodiversity research open, to moving towards that being the default, and to recognize that we need open around grand challenges like climate change if we are going to tackle these large and global problems. So I'll finish by saying thank you very much for having me here. I am looking forward to working at Creative Commons, but also specifically working on the Open Climate Campaign. If you have any questions about the campaign, we should be launching next month. Thank you very much for the invitation. And as suggested in the presentation, this presentation itself is also CC BY licensed to make it easier to remix and reuse the content that I have presented today. Muchas gracias.
Thank you, Monica. We appreciate your effort to be today at the conference. It's very interesting, and we encourage our attendees to write down your questions in the chat. Maybe if you want to share your video and we can see you, and maybe we can discuss some questions that we have prepared in advance. So one of the first questions that comes into my mind is concerning the differences among the CC licenses. You mentioned that Creative Commons is not strongly recommending the non-derivatives licenses, but are there some basic differences, fundamental differences among the CC licenses that you can explain?
Yeah, absolutely. You might have to hit something on your end for me to start my video, because it's still disabled when you get a chance.
Okay.
But I will do it vocally.
If you can select your camera on Zoom, it's maybe you should close the Prezi and just select the camera.
No, I know it should be easy, and this is not the first time I've used Zoom. It's disabled
Okay. Yeah.
from your
No
end.
worries. No worries. Yeah. So,
Okay, but let me answer that question for you. And maybe what I could do is send you folks to the licenses so you can see we do have different licenses, and there's a reason behind that, right? So the reason behind having different licenses really goes back to the reason why Creative Commons started in the first place, which is, there was a recognition that we wanted to make it easier to share knowledge while respecting copyright. But it can be very complicated to try to understand copyright and sharing if you don't have an expertise in that, or even if you're a lawyer, but specifically a lawyer on who works on copyright. And it also copyright changes. And so you'll hear, I think, a little bit more about this from a guest that you will have later on in the conference. So recognizing that, Creative Commons wanted to use that copyright infrastructure and make licenses that were easy to understand, but also gave you some options on how you wanted to license your work. So you can think about licenses being a bit on a spectrum from the most permissive to less permissive. So all the Creative Commons licenses allow, are designed to share. So it's not a way to not allow for sharing, just changing the way that you can share. And so the CC BY license specifically is a pretty permissive license. And the reason why we, as I mentioned, suggest that is that license is for the context of open science. So we are suggesting the use of CC BY because it is in line with the goals of open access. Other licenses that we have in that spectrum may be more appropriate for other uses. So there are licenses that allow, people to use your material, but as I mentioned, there's a non-derivative, meaning that you can't really change anything from that license. There's the if you add an NC, it means you have to attribute, but you can't have a commercial use. We also then have the option to have a non-commercial share-alike license, meaning that you have to use the same license in what new output you make from the original work. And then the least permissive or most restrictive is the CC BY NC and D. So that is, you have to give attribution, no commercial, no derivatives. So that allows others to download your work and to share them with others as long as they credit you, but you can't change them in any way or use them commercially. So the design of these licenses are to be able to give you some options in how you share your work, but specifically we want to highlight that for open science and for the pursuit of open science, we recommend CC BY licenses to really fulfill the potential of why you want to make your research open.
Okay, thank you, Monica. One of our next questions is concerning I think you already answered that question during your presentation, the non-suitability of CC licenses for software and code. But let's jump into our next question. What is the difference between attribution and citing?
Yeah, that's a really good question, especially in the scientific world or in the scholarly communication world. So a citation is specifically for, or usually for, copyrighted work. So that is work that has a copyright, and you're trying to show that that is where you got information. It's also really useful for bibliometric analyses, so to understand how research is connected and building up on each other. An attribution is for non-copyrighted work, so it's for work that you can that is designed to be shared. So the formatting of a citation, is as you usually see in a paper. It's so that you're saying this is where I'm getting information. Usually, so that you show that it's not plagiarized, versus an attribution where you can take material and remix it and reuse it, but just showing where you got the material originally.
Okay. I just want to emphasize that, as you mentioned, science is about sharing, or sharing is beneficial for science, but sharing is not copy-pasting, which is something that probably most people, young researchers, think, and it's not about that. It's giving credit, and that is one fundamental thing to remember in this conference. Our next question is how to give properly attribution to a work that has been published with a CC license, specifically with a CC license, since you are representing Creative Commons today.
Yeah, so I think the best option for that is we have suggestions on our website how to do that. I would start at the link that I provided in the chat. And there actually is software or plugins that you can use that show you how to do or that really give you automatically the text for attribution. So I will paste that in the chat, and the easiest thing to do is to just use one of these tools, so you get the exact text.
Okay, that's great. So we can continue with the questions from our attendees. So let's read one of the first questions. This attendee Yolanda has a very interesting question here. She's asking, are we really working for free for big corporations? And she's stating here, I think the situation with the COVID crisis, the big pharmaceutical companies were the ones who profit from the research, and in turn, and also they were profiting from the health of people. So, do you have a comment about this?
Yeah, I mean, I don't know where that I can speak to it from my role at Creative Commons. I can tell you sort of what my perspective is as a scientist, as a trained scientist, and that is that that most of the research that, and this will vary from country to country, but most of the research that gets done, at least in Canada, for example, is funded by the government. And so, that research is paid by the tax base in a particular country, and that my rationale behind that is then this is why we should make science for free. When you're talking about something like the COVID-19 crisis, there are many different aspects that need to be researched on even this single virus across many scientific subdisciplines, including molecular biology, virology, public health, social sciences, human behavior, behavioral change, and not necessarily do all of those intersect with pharmacological research. So I don't know how to address your question about, do pharmaceutical companies and how they are profiting. I think that's a discussion for a different day, and it's certainly the research that they do is not necessarily accessible. But I'm here to talk about how we can make our research more accessible, and how Creative Commons licenses can help with that endeavor.
That is correct, Monica, since I want just to point out that the open access movement was born concerning the fight of the monopoly on the publishing industry. So this approach really worked, and it's still getting better, since the European Union is implementing this Plan S policy on publishing for research outputs to be published in the open access model. So it's actually really good for all of us, since we have to emphasize that the research initially is funded mostly by public funds. So we are already paying this tax dollars are already paid by the taxpayers, and it's nonsense to profit from the articles that were originally funded by public money. So this is why the open access movement makes a lot of sense concerning this situation. So let's continue with our next comment or question from another attendee. So just let me jump into the questions. So it's the same attendee. She's just stating it's important to share the results of the research with other people. So this is actually one of the main things that we need to do as researchers, or the ones who are providing guidance to publishers, editorial teams, and governments. This is the best approach to do things, to share the results, but emphasizing sharing. It's not copy pasting. Sharing, it's giving credit for sure. Providing this research outputs, for instance, popularity of preprints. Preprints are actually really good. So this changed quite a lot the model in past decades about sharing science. We know that preprints are not peer review, but it's a good start to have feedback about the methodology, the results, the findings, and there are good ways to improve it based on the feedback from our colleagues. And if it's not shared, so nobody will know about the things that researchers that we are doing. So I think that we have covered the most important aspects of Monica's presentation. I don't know if you want to point out something else, Monica?
Just that I am grateful for everyone who is here. Thank you for your attendance. And I think everyone here believes in the need to be able to share science with as few barriers as possible. And that I encourage you to think about making it easier for scientists, social scientists that are publishing in your outlets to use CC BY licenses. Make it as easy as possible for them to use that license, to point them to an explanation of the CC BY license and why that particular license is going to allow others to build off of their science in order to help understand our world, and that these types of licenses make it easier to build on research. So if there is a way for you to have that option in your platforms, I highly encourage you to make that the default option.
Yeah, that's very important to emphasize. This type of licenses are really suitable for research outputs, especially in the Latin American region. We know that there are many journals that have adopted the open access model in the region, around 73%, 74%, I don't remember exactly, but it is actually a good start. However, we need to work more about other issues that we have observed, and that's the reason why we are preparing these events, in order to train editorial teams and to make them aware about these issues and the solutions that renowned researchers from these institutions are pointing out. So thank you very much, Monica. I know that you have to check out from the hotel and take your flight to Toronto, so good luck with that, and we appreciate that you presenting today. And for our attendees, we would like to mention that we are going to take right now a coffee break for about 8 minutes, and we are going to return for our next presentation. Yeah. So thank you very much to all. Let's have the coffee break, and thank you, Monica. See you, and let's keep in touch. Thank you. Welcome back, colleagues. Openciencia is very pleased that you are still attending the conference titled Issues in Open Access Publishing 2022. As we mentioned earlier, Openciencia continuously carries out international events, inviting experts to share their knowledge and experience to researchers, students, professors, and editorial teams. One of our aims is to train editorial teams improving the editorial work. In turn, the quality of research products that are published is increased. In this year's event, we are addressing some issues in copyright and licensing that we have observed in scholarly journals in the Latin American region. Let us remind you that our next presentation will be held in English language. Please select the correct interpretation language in Zoom. In addition, you can type during the presentation your questions in the chat. Please note that we require you to type the questions in your native language. We are going to translate them to the presenter during the Q&A session. Copyright and licensing agreements are essential in any scholarly journal. They are basically legal contracts between the publisher and author concerning the rights of use of the scholarly work. However, sometimes these agreements are poorly prepared, have contradictory terms, or there are some in conflict with the copyright law. Since our second presenter, Stefano Barraza, is not able to present today, we have prepared a presentation concerning copyright license agreements in scholarly journals. One of our colleagues has prepared a video introducing me. Let's proceed to watch the video.
Welcome back, colleagues. Openciencia is pleased to have renowned presenters from around the globe at the event titled Issues in Open Access published in 2022. According to Ulrich's Web, nowadays there are over 48,000 peer-reviewed scholarly journals worldwide. Although this number is impressive, it doesn't mean that journals comply with certain publishing standards. Regarding these standards, Cope et al. Described 16 best practices in scholarly publishing. Among these best practices, Cope et al. Indicated that journals must clearly state a copyright and licensing policy and comply with it. However, journals are not always compliant with them. For instance, Aguilera Arevalo pointed out that more than half of journals in Mexico and Guatemala have absent the copyright and licensing in articles. Regarding the protection of the work, it's a standard that journals require authors to sign a copyright and licensing agreement. Nonetheless, these agreements are sometimes poorly prepared, have contradictory terms, or do not comply with the local intellectual property law. Therefore, we have invited an expert on this topic, Dr. Humberto Aguilera, who is going to orientate us about these agreements. During his stay in Mexico for 5 years, Dr. Aguilera studied a bachelor's and a master's degree in psychology from Ibero-American University of Puebla. He also conducted advanced studies in the National Autonomous University of Mexico. Afterwards, he got a scholarship to study in the Czech Republic. He holds a PhD in social psychology from Masaryk University. Dr. Aguilera lived in the Czech Republic for 16 years. He was an instructor and a researcher at the University of New York in Prague and Charles University. He has been an academic mentor of bachelor, master's, and PhD students among different European and Latin American universities. Likewise, he was the editor-in-chief of Revista Internacional de Psicología for 20 years. He gained experience in the editorial work and evaluation of research projects. Dr. Aguilera has also worked as a consultant for NGOs in different countries, such as the Research Center for Human Development and Society in Guatemala. Likewise, he was a clinical monitor associate at Syneos Health, working on the development of new drugs. In 2019, Dr. Aguilera founded the academic organization called Openciencia, a sponsoring organization from Crossref. The organization has been providing solutions to issues that editorial teams, universities, researchers, and students are currently facing in their work. Currently, Openciencia is working in more than 8 countries, working together with editorial teams, universities, and researchers. Dr. Aguilera is currently located in Guatemala, although he often travels to Salvador, Mexico, and the Czech Republic. He is today with us presenting the topic called Copyright and Licensing Agreement in Scholarly Journals. Please, let's welcome Dr. Aguilera.
Thank you, Teresa. I appreciate your introduction. And since it's not possible to present the slides at the same time in the conference, I pre-recorded the presentation, so this is the one that you are going to watch right now. Good morning, colleagues. My presentation is about copyright license agreements in scholarly journals. Let's begin with the introduction to the topic. Promises in return for something is the daily bread of the publishing industry. However, this quid pro quo cannot last in the absence of regulations. Regulations help to enforce and protect the parties involved within these promises. In addition, regulations aid to resolve disputes when these promises are broken. We find among these regulations the copyright law that enforces and protects authors and their work and publishers. Within the scope of the copyright law, publishers promise to publish, distribute, translate, and sell the work of authors in return for royalties. However, these promises must have been accepted by the author in the first place when submitting the work to the publisher. Therefore, we can identify an agreement. But what is exactly an agreement in the legal context? In order to understand an agreement in the legal context, we are going to try to define it. What is an agreement? In contract law, Black in 2012 defined an agreement as the following. Person A offering X to person B plus person B accepting X. For instance, a publisher offering the author to publish and sell a book, plus the author accepting this promise. Therefore, Black in 2012 explained that an agreement is a promise or an offer or a series of reciprocal promises or offers which constitute consideration for the parties to contract. In other words, an accepted promise or offer, or a promise or an offer plus an acceptance. Based on the definition, we can identify certain elements of an agreement. Let's explore these elements. With respect to the elements of an agreement, Black in 2012 indicated that there are two elements, such as promise or an offer and acceptance. Both are essential in every agreement. Let's review the promise or the offer. As regards the promise or the offer, Peel in 2007 mentioned that is the willingness to agree on certain terms, created with the intention to be binding as soon as it is accepted by the person to whom it is addressed. The one who makes the offer is the offerer or proposer, whereas the one to whom the proposal is made is considered as the offeree. Let's review the acceptance. Peel in 2007 pointed out that the acceptance is the final and unqualified assent to the terms of an offer. In other words, agreeing absolutely or without any conditions or limitations to the terms of an offer. Let's review an example. An example will be a publisher offering an author to publish and sell his article. However, the publisher has certain conditions or terms. For instance, among the conditions, the publisher requests the author to transfer the publishing rights for 5 years. Then the author accepts the offer. Therefore, it becomes an agreement. In this example, we observe the promise from the offeror, the publisher, and the acceptance from the offeree, the author. When the author accepts the promise, it means that the author absolutely agrees to the terms of the offer. Nonetheless, in law, an agreement is not a contract. However, all contracts are agreements. Let's explore deeper contracts. To comprehend a contract, let's try to define it. What is a contract? As defined by the Legal Information Institute in 2019, a contract is an agreement between parties in which there are legally binding mutual obligations. In other words, it's a legally binding agreement. Hand in 1911 defined it as an obligation enforced by law to specific acts of the parties that commonly accompany and represent a known intent. Contracts, as well as agreements, have certain basic elements that are important to address. What are these elements of the contracts? Well, the Legal Information Institute in 2019 listed 4 basic elements that are the following. The adequate consideration. The adequate consideration is, in other words, the mutual exchange that must imply a fair price in comparison to the offer that is made in exchange for it. For instance, an author must consider fair the transfer of publishing rights to the publisher for 5 years in exchange for publishing and selling the article. Let's see the following element, mutual assent. Mutual assent means that there must be an agreement by both parties. It must be proven objectively by showing an offer and acceptance. Let's continue with other features such as capacity. Capacity is basically the person's ability to meet certain requirements to enter binding contracts. For instance, reaching a minimum age and have soundness of mind. Let's end with the last feature, that is legality. Legality concerns to the lawfulness or legality of the purpose of the contract. The purpose of the contract must fall within the law. As we learned, these are the basic elements. However, in some legal contexts, it is included the breach of contract. Besides these elements, there are some considerations that we must mention before finishing the introduction. In contract law, contracts are enforceable. Raptis in 2022 explained that a contract is enforceable when one party can hold the other contracting party to their promise if they fail or refuse to uphold it. Holding the other contracting party is possible by a lawsuit for breach of contract. Notwithstanding, there are other scenarios in which contracts can be found unenforceable due to a variety of reasons. For instance, lack of capacity, coercion, misrepresentation, and others. Within the publishing domain of scholarly works, we can find copyright and licensing agreements. Let's explore deeper these agreements. The copyright license agreements, a standard requirement in scholarly journals, are in fact contractual agreements. In other words, in the scholarly publishing domain, copyright license agreements are essentials. Why do publishers need them? Well, there is no other way to publish copyrighted work from authors unless breaking the law. Since publishers don't want to get into trouble, they abide by the copyright law and provide these agreements to authors before submitting their work. Therefore, it is essential to know that the clauses or provisions that these agreements must contain. Although we are discussing these agreements in this presentation, we strongly advise publishers to consult an intellectual property lawyer who can thoroughly check the ones that you have in use. The intellectual property lawyer is the most qualified person who can assess whether the agreements are well prepared or not. Although these agreements must take into consideration all the provisions that we are going to mention, there are some, based on the jurisdiction where you live, that we are going to miss. Sember in 2022 indicated that copyright license agreements are contracts between the copyright owner and the licensee. In addition, Sember explained that these contracts contain provisions such as the parties involved, copyright, licensing, fees and royalties, non-disclosure agreement, and others. Let's begin with the parties involved in the agreement. Well, we have the licensor. Sember in 2022 indicated that the licensor is the copyright owner. It is the party who is providing to the other one the copyrighted work. In the scholarly publishing domain, the licensor is regularly the author of the work. It might be other person or institution if the copyright has been transferred. It is very important that the copyright owner is correctly identified as the licensor in the agreement. Let's review the licensee. Sandberg pointed out that the licensee is the one receiving certain rights from the licensor. In the scholarly publishing domain, the licensee is regularly the publisher. It is very relevant that the one receiving the rights is correctly identified as the licensee in the agreement. Once the parties are correctly identified, it is relevant to understand the clause regarding the copyright. Concerning the provision about the copyright, the World Intellectual Property Organization mentioned that it refers to the rights that creators have over their work. Other authors, such as the US Copyright Office, stated that copyright as intellectual property protects the work as soon as it is tangibly fixed. To clarify the definition, the World Intellectual Property Organization explained that copyright concern the protection of economic and moral rights. The ones that are usually transferred are the economic rights. The WIPO added that moral rights are usually not allowed to be transferred in many countries. Therefore, in copyright license agreements, we observed that economic rights are the ones in the equation. There are two crucial aspects that must be clearly stated in any copyright license agreement: the copyright holder and the copyright assignment. Let's review the issue concerning the copyright holder. In the agreement, December in 2022 described as essential the statement about the one who is the copyright holder. In other words, the one who is the copyright owner. As we mentioned earlier, there are certain situations in which the author or creator is not the copyright owner. For instance, if the work is part of the job tasks of an employee, the copyright owner might be the institution. In other situations, the copyright owner might be other person if the copyright has been transferred. Nonetheless, in the scholarly publishing domain, the copyright holder is usually the author of the work. Let's review the copyright assignment. Taylor, in 2012, pointed out that the copyright assignment is the transfer of ownership of the copyright. It usually involves the transfer of certain economic rights from the licensor to the licensee for a certain time. For instance, the publisher requests the author to transfer of certain economic rights, such as reproduction, distribution, performance, translation, and adaptation, among others. Within the publishing realm, in scholarly works, the transfer of certain economic rights is essential for publishers to reproduce the author's work. However, Thomson Reuters in 2022 indicated that in certain jurisdictions such as Mexico, Brazil, Indonesia, Italy, and the UK, the transfer must be in writing and signed by both parties. Thomson Reuters also pointed out that in certain jurisdictions, such as Mexico, the licensee must pay the licensee must pay the license for the licensee must pay the licensor for the transfer of economic rights, and the assignment must be registered to be effective against third parties. Therefore, we strongly recommend checking in your jurisdiction the requirements of the copyright assignment. In addition, we encourage publishers to request only the necessary economic rights to be transferred from the author. Furthermore, we recommend publishers to consider a reasonable period to hold these rights. It is important to be fair with authors concerning the economic rights of their work. Other important provision of the agreement is the licensing. Let's check it out. Licensing is basically the copyright owner granting a license. What is exactly granting a license? Samber in 2022 stated that granting a license is the copyright owner or the licensor giving a third party, the licensee, the right over the copyrighted work for something in return. In other words, the copyright holder giving others permission to use the work in exchange for something. It is important to clarify that the right over the copyrighted work always falls within the terms of the license. Furthermore, when granting a license occurs, the copyright owner always retains the copyright of the work. There are important differences to acknowledge. Copyright assignment and granting a license are not the same. The latter means the author leasing the copyrighted work for a fee but retaining the copyright. Thence, licenses have limited use compared to copyright assignments. In the scholarly publishing domain, granting a license happens when the author of the work gives the publisher and others the right over the work, expecting royalties. But what is exactly a license in this context? Let's try to define a license in the context of intellectual property. According to Kohler in 2018, a license is an agreement between the copyright owner, the licensor, and the third party, the licensee, concerning the right limited to the terms of the agreement to use the copyrighted work. A license is commonly used to provide extra revenue and royalties from a wider exploitation of the work. However, the World Intellectual Property Organization in 2016 indicated that licenses are legal alternatives in jurisdictions in which copyright assignment is not allowed. In the publishing sphere of scholarly works, Licenses are these agreements that copyright owners, such as authors, choose among the ones that publishers work with. There is a variety of licenses that can be clustered based on certain features. Let's explore the different type of licenses that we commonly find in the scholarly publishing domain. As regards the type of licenses, Sauber in 2007 indicated that licenses can be clustered based on the restrictions they impose to use the copyrighted work. Thus, Sauber described traditional licenses and open access ones. Sauber in 2007 pointed out that traditional licenses impose many restrictions and barriers to third parties to reuse and transform the copyrighted work. In the scholarly domain, this type of licenses limits the progress of science, since researchers must request permission to the copyright owner to reuse and transform the work. The traditional publishing industry, that in most cases owns the copyright of the creator's work, prefer this type of licenses since they can have more revenue and exploit better the work. In contrast, Sovereign 2007 outlined that open access licenses have fewer restrictions and allow the reuse and transformation of the copyrighted work, making research easier for all parties involved. Researchers need not to request permission to reuse or transform the work. Thus, the progress in scientific disciplines can be eased. Generally, the terms of open access licenses are aligned with a fair policy for the stakeholders on a freely dissemination, reuse, and transformation of the work. Therefore, we encourage publishers to work with open access licenses. There is other type of licenses based on exclusiveness. Let's review it. The World Intellectual Property Organization in 2016 indicated that a license is exclusive when the copyright owner doesn't allow other parties to perform the licensed acts. On the contrary, the World Intellectual Property Organization explained that a non-exclusive license permits other parties to carry out the rights specified on the license terms. In the scholarly domain, the author granting an exclusive license to a specific publisher means that other publishers are not allowed to carry out the licensed acts. With respect to the dissemination and transformation of the work, granting an exclusive license imposes important limitations. For instance, other researchers won't easily find the research outcomes. In addition, the work cannot be transformed into an invention since other parties are not allowed to do it. Thence, we strongly suggest publishers to request authors to grant non-exclusive licenses providing a positive impact of the research outcomes. In addition, the license terms are essential to describe in the copyright license agreement. The terms of the license must be clearly described in the agreement. The terms should be written, leaving no room for ambiguities and misinterpretations. Since the copyright owner allows other parties the right to use the work, the type of right and licensed acts must be clearly specified. In the scholarly publishing domain, we strongly suggest publishers to encourage authors to grant them open access licenses, such as the one from Creative Commons. The advantage is that the license terms are predefined, and publishers need not to worry about preparing the license terms. Other provision that is commonly included in copyright license agreements is the one about fees. Sandberg in 2022 indicated that there are some fees that are specified in the agreement. Sandberg in 2022 explained that some are royalty fees and others are the copyright ones. The royal fees are usually calculated based on the sales of the work. In contrast, the copyright fees are related to the purchase of the copyright license. These two types of fees are common concerning the copyright licensing. In some jurisdictions, the copyright assignment must be paid by the licensee. In the traditional scholarly publishing system, the royalty fees are common to find. However, they are not common in the open access domain. In addition, the copyright assignment paid by the publisher to the author is symbolic. There is other clause that every copyright license agreement must include. It is related to the confidentiality of the agreement. In contract law, it is common that the information in contracts remain confidential. In addition, it is required by law. Thomson Reuters in 2022 indicated that the non-disclosure agreement helps to protect the information when both parties promise not to disclose confidential information to a third party without authorization. In the scholarly publishing domain, publishers must keep confidential some information submitted by the author. For instance, the content of the copyrighted work remains confidential unless it is published. We strongly suggest publishers to prepare this clause with the help of an IP lawyer. There are other provisions that are important to mention. Sandberg in 2022 indicated that there are other clauses or provisions that are relevant to include in the agreements, such as determination, effective dates, and geographic areas. Let's review termination. As regards the termination or severance clause, Sember in 2022 pointed out that it allows parties to end the agreement without breaching the contract under early or mutual termination. The advantage having this clause is that the contract cancellation doesn't result in penalties. Therefore, the terms must be carefully prepared. We strongly recommend publishers to prepare this provision with the guidance of an IP lawyer. Let's review the effective dates. Sember in 2022 stated that there must be effective dates of the agreement. In other words, the date that the agreement becomes binding. The last provision that we are going to mention relates to the geographic areas of the license. Sember in 2022 stated that the agreement must contain the geographic areas where the license applies. We strongly recommend publishers to adopt open access licenses such as the ones from Creative Commons, since they are valid worldwide. As regards the provisions that we mentioned in the copyright license agreement, there are some that we probably missed. It is important that publishers contact the expert, an IP lawyer, who can aid reviewing the agreement and include provisions that we didn't mention based on the jurisdiction they operate. Based on our research results, we have observed some issues in scholarly journals that are relevant to mention in this presentation. In the Latin American region, we have observed issues regarding the copyright license agreements that are quite worrying. Let's start reviewing these issues. The first one is about the lack of disagreements. In a study that we conducted in 2022 on scholarly journals in Mexico and Guatemala, we found that most of them don't provide a copyright license agreement. Although these journals provide in some extent the terms in Open Journal System, it is not sufficient. The copyright law in these countries require that the agreement must be provided in written form and signed by both parties. Let's review the other issue that were common among the journals that provided the agreement in written form. Interestingly enough, we discovered that most of these journals didn't have the minimum provisions required in these agreements, such as the licensing terms, non-disclosure, signatures from both parties, and termination. In other words, we found incomplete agreements. We also found other issues with respect to agreements in conflict with the copyright law. There were few agreements that have conflict with the copyright law, such as the licensee, publisher, granting the license, or the journal as the copyrighted work. Hence, it is important that publishers are properly guided by experts, such as IP lawyers, in order to avoid these issues. In the Latin American region, having the majority of publishers within the open access movement, it is worrying that most of them are lost concerning the understanding and preparation of these agreements. Therefore, it is fundamental that they get schooled to fill out the knowledge gaps concerning the legal domain related to their journals. Then, what can we conclude? We can conclude that the agreements are not easy to prepare for beginners in the copyright law. However, it is possible to learn it. Thence, we encourage publishers, authors, funders, and readers to be aware of the required provisions that copyright license agreements must contain. We also encourage publishers to consult experts such as IP lawyers to revise the agreements that they have in use and amend or add the provisions that it must contain. It is also important for publishers to play fair with their copyright owners. The open access movement reflects the right path to follow, allowing science to progress. Therefore, we encourage open access licenses and the retention of the copyright by the author. Thank you very much. So we appreciate you staying during this presentation. We will like to ask you to write down your questions in the chat, and we are going to proceed to answer the questions. So it's important to emphasize that these copyright license agreements are very relevant in the publishing domain, and we have observed certain issues that we need to address, especially in the Latin American region. Based on our findings, we have encountered that there is an issue concerning the preparation or the lack of these agreements. Editors-in-chief don't have the copyright law knowledge, the sufficient copyright knowledge in order to prepare them correctly. Therefore, we have observed incomplete agreements or agreements in conflict with the copyright law, since if you're not an expert on this area, on this domain, so you are prone to make mistakes concerning these agreements. Therefore, it's important that you get some help from an IP lawyer, from an intellectual property lawyer, who can guide you or who can revise the copyright license agreement that you have in use in your journal, in order to amend it or to add some clauses that are missing, and check whether the journal is compliant, fully compliant with the copyright law. So that's the reason why we are also preparing these events, seminars, conferences, in order to address these issues and find out how we can help. Stefano, luckily we have the good news that Stefano is going to present after the event, and we are going to have more information, orientation, and tips in order to address better this issue in scholarly journals. So let's check the questions. I'm not sure whether you have some questions here. So let's just wait a few few more minutes in order to have some questions written here. So we are a bit behind our schedule. We must have a break right now. So there is a question from an attendee. Okay, thank you. It's just an attendee, Yolanda, who is stating that the conference is very interesting. Thanks. Do you have any more questions? Please write them in the chat, and if you can ask after the conference is over, so you can email us, and we are going to provide specific answers for your questions. So let's proceed. If there are no more questions, we apologize for the inconvenience concerning the interpretation from English-Spanish interpretation. The interpreter has some issues with the audio, so I hope that the interpretation in the following 2 sessions will work correctly. So let's proceed to take the coffee break, and we thank you for staying at this conference.
Welcome back, colleagues. Openciencia, it's really grateful with you to be here. Title: Issues in Open Access Publishing 2022. We previously mentioned Openciencia carries out continuously international events where we invite experts to share their knowledge and experience, also researchers, students, professors, and editorial teams. One of our goals is to train editorial teams, improving editorial work. At the same time, this improves the quality of research projects. In this year's event, we're talking about some issues to copyright and licensing that we have observed in journals in Latin America. Our next presenter will be in Spanish. Please select the interpretation language you want to listen to. As well, you can write during the presentation your questions in the chat. Please remember that when you write a question, it needs to be in your native language. We will translate it to the presenter during the Q&A session. Copyright and licensing are essentials to protect the work and also to have a control of how it is used. Nevertheless, copyright legislation will vary from country to country. In Mexico, the legislation to copyright has some very specific aspects. Our third presenter today is attorney Abigail Alquicira from the National Institute of Copyright in Mexico, We are pleased that experts in copyright can be part of this event. Attorney Alquicira will present copyright and licensing in journals in Mexico. One of our colleagues from Ecuador, Carla Flores, will present a video to introduce her to us. Let's watch it. Good morning, colleagues. We are pleased to have different colleagues from different parts of the world in the Issues in Open Access Publishing 2022. According with Arevalo Aguilera in Mexico, there was an increase of 310% in academic journals from 2000 to 2021, reaching to 1,323 journals with an ISBN. Nevertheless, this increasement has happened without difficulties. According to Aguilera Arevalo 2022, academic journals, more than half, did not have copyrights and licensing. To talk about this and other issues, we have invited attorney Abigail Alquicira Fernandez. Attorney Alquicira holds a bachelor's degree in law by the University of London. Also studied intellectual property, corporate law, public hearings, and law of civil procedure. In 2012, she began working at Indautor with an internship. That same year, she was hired to be in charge of registrations to the institute. In 2014, she started as an attorney examiner to issue contract reports, certificate requirements, refutations, amended registrations, and terminations. In 2017, she began collaborating as a legal expert in the judicial department of the Institute. Attorney Alquicira has been part of national events related to the copyright. In 2018, she talked about registration created by the Mexican Alliance of Creativity. In 2020, she presented about the Marrakesh Treaty related to copyright and issues to access with persons that are visually impaired. It was organized by the Attorney College of Valle de Mexico. Please, let's welcome Attorney Alquicira. Today she will present copyright and licensing in academic journals in Mexico. Thank you very much, Attorney Carla Flores, for presenting Attorney Alquicira. Let's welcome her. Please share your video and start your presentation. Okay, I've just started sharing my screen. We can see it.
Entonces, creo que no los voy a poder ver.
I don't think I'm able to turn on my video. Don't worry.
Si gusta poner las diapositivas también puede ser. Si no, mira las notas ahí.
As you wish.
Poner su...
No te preocupes. Creo que por lo que he estado escuchando, pues la mayoría de ustedes saben lo que es la propiedad intelectual.
Okay, I think most of you know what copyright is, right?
Yo quisiera mejor enfocarme antes
I want to focus more before I explain copyright, because I think most of you have a vast knowledge about it.
Quisiera
I would like to
referirme un poco a lo que son los derechos de autor
talk
en
about
México,
copyright in
que
Mexico.
pues obviamente por tratados internacionales pues estamos
Obviously, through international
regulados en la mayoría
treaties
de los países
are enforced,
por estos convenios internacionales y porque pertenecemos propiamente
and also because we are part
¿Sí me
of
escuchan?
WIPO. Can you listen to me?
Sí, por supuesto, le escuchamos, licenciada, sí. Continúe.
Ok, entonces, a lo que me gustaría referirme hoy, más que nada, es como aclarar.
Today I want to talk about, really clarify,
En cuestión de que, por ejemplo, las obras en México están
regarding works in Mexico are protected by copyright once they are fixated. Once the painter is done with painting, the sculpture done with the sculpture, or the musician who's just finished writing the last note to the song. From that moment on, any individual that has created something with their knowledge, with their hand, immediately acquire copyright, patrimonial rights on their work. Within those moral rights, it's the one to decide if the work will be published and who can republish it, or decide if it can be a derivative work or not. The author can decide if it will be published on its own name or as pseudonym. All of these prerogatives are part of moral rights. They're unseizable, inalienable, and unrenounceable. No one can renounce to them. Once the work is fixated on material, the author has moral rights on the work. I think we all agree on that. The duration of the patrimonial rights in Mexico are the life of the author and 100 years following the author's death. I think we're the country with the most duration from the WIPO countries. The Berne Convention states the duration of patrimonial rights. It can be during the life of the author and 50 years following the author's death. But Mexico has modified it to 100 years following the author's death.
Bueno, los derechos de autor y los derechos conexos, estos derechos conexos.
Copyright and neighboring rights are ones related to the authors. We understand copyright or author as the material that producers use of phonograms, multimedia, artists, interpreters, performers, or editors, or radio, to take the work, edit it, produce it, interpret it, or broadcast it. These neighboring rights have to be in Mexico. They have to be authorized by the author or by collective societies that the author has appointed to.
Sus regalías o cobre sus regalías en su nombre y representación.
They can get profit from it. This means that the author and the neighboring rights are related, and they're extremely interrelated. One cannot live without the other.
Estos derechos patrimoniales son el conjunto
These
de
patrimonial rights are the faculties that the legal or individual can use
económicos que se obtienen dentro de las obras. Entonces, estos derechos patrimoniales
These patrimonial rights can be transmitted to third parties
pueden ser transmitidos
and can be used in Mexico or transmitted in Mexico in 3 different ways. Cession of rights through a legal relationship, the license. The license, there's no that transmission of rights. A license is the authorization so that person can use that work without obtaining rights or obligations. Obligations about a profit or a privilege to the author. The licensee will not obtain patrimonial rights on the work. In this agreement between societies or individuals, it's extremely important that the author to establish on the contract the use of the work, if it can be derivative or not, if it can be edited or produced or interpreted, or if it's a license that can be derivatives or transmitted
vía cualquier organismo de radiodifusión.
Through any broadcasting way.
Dentro de estas licencias, pues
within licenses,
la licencia de uso exclusivo y
there's exclusive license.
Dentro de la licencia de uso exclusivo, pues tiene que
estar the exclusive license,
dentro de este contrato que es de forma
there needs to be established in this contract that it's exclusive. Article of 35 of Free Right in Mexico, it says that exclusive license can be, will provide rights to licensee unless acted differently, but the work can be used exclusively and it cannot be transferred to third parties. So on the contract, it needs to be established if this work can be licensed or not. Everything has to be stated on the contract. Now, the federal law of copyright also states all of other contract licenses, edition or production or work for hire of work relation have to be registered in the copyright institution. And they have to be also notarized. It's extremely important that within the licenses or contracts, it is established what the author wants and needs and the use of the work, or if it can be sub-licensed or can have derivatives. And the privilege that the author can have from this license and for how long. The federal law of the copyright states that there's a duration and also an amount. This will be
Y a pesar de que no nos marca
by
estrictamente
the incumbents,
que la licencia tiene que tener una temporalidad,
the license duration, it's not stated on the law, but I consider that it is important.
Entonces, bueno, a diferencia de las licencias, pues en la sesión de derechos sí hay esta
In the session of rights, there's a transmission of patrimonial rights, and it states that it has to be written. It's extremely important that during this session of rights, transferring, indautor cannot be part of it. We cannot provide templates. Go beyond the faculties that have been assigned to us. This is just between the authors and third parties. It's important to take this into account and to specify the rights that you're going to transfer. If it will be a reproduction, transmission, how many copies will be published, among others. It's important that all that information, it's part of the contract. The difference with the transfer of rights, there's another judicial representation that's work for hire that per se, it's when a person, when an author different to the author hires someone else, provides the idea of what he or she needs, and hires the person to do it.
Le especifica o le da las instrucciones necesarias.
This person specifies the instructions to create the work. This legal entity or individual tells the author what he or she needs for when, and also pays so the author can create. The patrimonial rights are born from the person that creates the author, but the author keeps the moral rights. It's important to take into account the difference between transferring of rights and work for hire, because the transferring of rights, the author creates work and transmits the rights to a third party. But in the work for hire, the third party, either legal entity, individual, tells how to hire the person and pays to create. So patrimonial rights are born with the person that creates or that's hired. Another important aspect is work relationship. Article 84, that when there's a work derived from a work relation, the law states very important that everything needs to be written. Otherwise, patrimonial rights are divided equally between the employer and employee. So if in this individual contract, we have that the author, well, it's not established on the contract who are going to be the owners and the percentage they receive, it will be a 50-50 for employer and employee. It's important to establish that the author cannot use the work without the employer authorization. Maybe employer gives authorization to publish in several different media forms. This is very common in Mexico. In institutions that are hired for work editing, for example, for commercials, graphic design. These authors are hired just to create editing for audiovisuals or graphic design work.
También se da mucho.
Fashion design, that's really common too.
De relación laboral, ¿no? Contratos individuales de trabajo directamente con
It's their work contract.
Ok, en las licencias, la Ley Federal del Derecho de Autor también nos marca.
Federal Law of Copyright
entre ellos el contrato de edición.
Also talks about editing contracts. Editing contracts, the author signs with a publisher. Not really a transfer of rights, but a contract between the author and the publisher, and must give the work, and the publisher has the editing neighboring right to publish it and to get the privilege and royalties to the author. I've seen cases when the publisher makes one sole payment to the author and later on signs the contract once all the copies are sold. They will probably sign for 3,000 copies until the 3,000 have been sold by a publisher or libraries, and the publisher paid. That contract is still current until the copies are completely sold. The patrimonial rights will be back to the author. For the editing contract will end once all the copies are sold. A new way or section in the contracts includes downloads. For example, Amazon or any other platforms where you can buy online books. It establishes the download things during certain periods. For example, January 2022 to December 2022, the amount of downloads, and based on the number of downloads, this is the amount that will be paid to the author. So it is subject to the number of downloads. Also, diagrams, typography,
pues todo esto que hace
have to be taken into account by the publisher to request ISBN, marketing by libraries, publisher. All of these expenses will be taken care of by the publisher. As I previously mentioned, in Mexico, we have this article in the law, Article 32, that states that we have to register contract for the third parties. Besides the registration, ISBN, we have to register the contract. And later on, once we have the physical work or finished work, then we can also register the edition. And the expense will be in charge of the editor.
Es que creo que esto estaba acá. Ok. En esta pequeña grafiquita, bueno,
In this graph,
los 4 trámites importantes que
you can see the 4 processes that have to follow, or that part of the process at the Copyright Institute. The one in red is done by the author. It is not mandatory because the work will be protected once it's material fixated, but it's important for the author to have this registration number before in the autor to have this relation and a certificate of registration. The certificate of registration is 300 Mexican pesos. You can do it in person or you can do it completely online within the Darlene system. With this system, we can log in, and with the digital signature, we can obtain the certificate in less than 2 days. Once the author signs this editing contract or this transfer of rights for this work for hire, the owner can register the contract. It's also done with us. We don't have an online registration for this process. You can also do it in person or send through courier service, and the cost is 1580 Mexican pesos. Once the owner has received the certificate of registration of contract, then the person can obtain the ISBN, and it can also be registered. And this can be done through our specific platform, that is www.autor.com.mx, and the specific platform to obtain the ISBN. And the price, there's 2 different prices. $258 is to obtain ISBN, but if you want a barcode, the cost is of 186 pesos. And once the work's printed and ready to be sold, then we can do the editing registration, and the cost is of 300 Mexican pesos. Those are the 4 processes that we can do at in the author institution. These are the 4 processes that we need to follow to publish in Mexico. So far, I don't know if anyone has any question.
Sí, licenciada, lo que nos gustaría muchísimo.
There are some questions, and we would like to for you to talk about. There's many editors that work for journals right now in the audience. What are the steps that they need to take to be copyright owners? According to the law, as in the books, there's also a process to follow with journals, with monthly publishing. And there's something else I want to know about Mexico. How can you simplify this process if we're talking about open access licenses? Does the cost cover the registration of open access licenses? But I think also it's important to simplify the process.
publicaciones de revistas académicas por internet y entonces nos gustaría saber si hay alguna posibilidad
There's many
contemplando
online
a
journals,
mediano plazo implementar
but
una
we would like to keep in mind
facilitación para el registro de esos
the
contratos
process
debido a
to
que la gran
register
mayoría de revistas
contracts or
para los entes
online
superiores de revistas
journals,
académicas lo hace con fines de diseminación del conocimiento científico y
because the purpose is to share the knowledge, scientific
no hay
knowledge.
cobros ni regalías a autores, entonces por eso nos gustaría
If it's open, there are no privilege. But can you explain this more in detail?
Como lo comentaba, la licencia de derechos,
As I said, the transferring of rights,
es simplemente eso,
it's
la
only
autorización
that.
para obtener el uso de esa obra.
It's
decir, cualquier persona
the right to
que
use the work. Any person,
bueno, yo sé que no puede ser cualquier persona, tiene que
well,
ser
not any person, but
especializados,
authors specialized in the field, scientific,
profesores
or professors, or researchers
que realicen estas
that carry out
realicen estas obras, le puede
this
otorgar
work.
esa licencia a cualquier persona, ya sea físico o moral.
They can provide this license to individuals and legal entities.
Ejemplo,
For example,
una revista científica que esté plenamente
a scientific
comprometida
journal
puede realizar un...
can,
No está en mi presentación, pero se los
this is not part of my presentation, but I want to point out that we have this specific power registration. You're going to show the contract in person in the institution, and this process is 8 to 15 working days, and we give you this registration of power. With this registration of power, you can do any of the other processes in the institution. This way it's easier to register the contract or the works or the ISBN. With this power of registration, then you don't have to show your contract. You just present a simplified copy of this registration of power. And with the registration of power, you don't have to show all of the documents that you have used to register previously. This is a way simplify the processes. This contract registration currently, because of the COVID-19, there was an email address on enable, so you could send all your documents. We were providing a provisional number, then request an appointment. But now we're back open from 9 to 2. We receive your documents, and the attorney receives all of your documents, and to have a resolution, it takes 3 days. It used to be 15 days, but now it's 3 days. In the contract, you have to read all of the clauses. So this could take a bit longer. So
para darles a ustedes
issue several certificates, but it takes a couple days because we have to read in details the certificates we provide to all of you. So contract registration takes 3 days.
Para la obtención del número ISBN
ISBN number.
Con este registro de poder o probablemente ya teniendo su representante único ante el instituto. Bueno, el término actualmente creo que son
right now. It takes 5 working days, and we take 5 working days because of the payment.
No sé si la mayoría de ustedes conozcan el
How
sistema.
do you know the ISBN online system? We upload the system. We upload the payment to the system. And once it's confirmed, we request the number, and it takes 3 days to receive the confirmation. And when it's enabled and confirmed, then we issue ISBN. So the 5 days, it really takes only practically 2 days to us. To receive the payment confirmation, it's what takes longer. To register works Monday, Wednesday, and Friday from 9:30 to 2 p.m. We are receiving everyone that was scheduled during the COVID-19 crisis from August 2020 to December 2021. Can you hear me?
Por supuesto.
Okay. Escucho un poco de interferencia.
Quería hacerle un comentario y
I want to make a comment
aprovechando que está usted aquí.
Sí.
and ask you. The comment is that we observed on this research from last year, at the beginning of this year, many journals and editorial teams have these contracts with clauses, well, incomplete contracts with clauses that should be there. But we see the need. The need recommendation, especially because you in the authority deals with ISBN number. Our recommendation, well, we want to ask for a recommendation for the drafting of these contracts. Sometimes they are disoriented, they do not know where to begin. Can Indautor have this information, a template really on their webpage for authors to know where to begin? We cannot do that. We cannot have templates on our webpage or contract templates. Why? Because these are agreements between individuals or third parties, and this can carry problems. So what the Institute, Copyright Institute can do, or before the pandemic, we began some workshops to teach. With Leonardo Conde and with me is to teach workshops and courses on how to draft contracts. I think if authors have more information and publishers know more, there will be more benefits. There's another process that we have in the Institute about meetings where we can solve problems where the privileged have not been paid.
Para justamente la negociación de estos contratos.
This way the contracts can be negotiated if there's already been a problem. This way, staff from Indoctor can sit with you and help you reach an agreement.
Esa junta de venencia, como le comento, o sea, no solamente es para la resolución de
Those meetings are not only for conflict resolution, but also as a way to negotiate for their points with contracts. I have another question. What happens if publishers don't register contracts? And not only in Mexico, but in some other countries where it's a requirement to register contracts, transfer of rights, or a license assigned to a third party. What could happen? What situation or problem can arise not drafting a contract? I know the copyright law protects the moral rights and also patrimonial rights. But once there's this transfer of rights written, journals, sometimes there's this contract, but it's not registered before Indoctor. What could happen? Can you please explain? There's a conflict when the contract is not compliant. Yes, the law states that we have to register the contracts. What does this mean? The moment that we go to the unit to research in Mexico, and it is attached to the Mexican government when there's the contracts don't comply. The first thing they will ask if we have registered this contract. That's the first question.
Si realizamos un contrato con aquella persona que está, y en el caso específico de un incumplimiento de contrato,
specifically if there's no contract compliance,
para el incumplimiento de este contrato, de igual manera, el juez lo primero que nos va a pedir
the judge, the first thing that's going to ask is a contract registration, because they understand there's an expert in the field that reviews the contracts.
Se basan muchas veces en ese contrato o en ese registro de contrato, ¿no?
And most of the process is based on the contract.
Entonces sí es una situación seria. Bueno, yo creo que lo que nosotros podemos abogar, y en especial Openciencia, que trabaja con
especially Openciencia, that works with publishers from several countries in Latin America, it's to make this process easier. Truthfully, there's many cases where publishers have problems surviving, and if there's not a profit in the process, and it's difficult to stay current. This happens with universities and publishers that with a lot of effort receive, arbitrate the works, and they do not receive any profit. Let's consider, I'm asking this because you work in the Copyright Institute in Mexico. To guide the journals, open access journals in Mexico, or well, in other countries. I understand that we must comply with law, and in any country. But if you can help the work of editors easier, because sometimes it's really difficult, or it looks as if it's difficult. In many cases, sometimes there's no privileges. Yes, of course, I know that to obtain the ISBN, you need to have the rights, and this costs 2,000 pesos.
La renovación cada año.
And you have to renew this license. And this has a cost too. It's over 1,000 pesos to renew or to register the rights. Besides the registration of contracts and the works or of editions, I'm aware that all these processes have a cost. But let's keep in mind that the Copyright Institute is decentralized from the Culture Secretariat, and our fees are not high and are not established by the Culture Secretariat. Our fees are established by the Tax Revenue Office in Mexico. Last year, we negotiated that the ISBNs should comply with the Marrakesh Treaty. We're free of charge. Really, the Institute cannot do much about it because the fee, it's not really directly received by the Institute. And believe me, I will say this as Abigail and not an attorney that works for Indautor. Many times we know that as employees, it would be better if the payment, the fees, that money was received by the Institute, like the INPI in Mexico. They receive the fees directly.
En el caso del Indautor, no es así.
So, Indautor doesn't receive the fees directly, just like the Propulet, just like INPI. So, we would have to talk to the Tax Revenue Office in Mexico to see if we could do offer a fee waiver. But so far, we have not received any fee waiver. I don't think there's a possibility. Unfortunately, regarding the fees, the institute cannot do much unless there's a change. For example, a couple of years ago, we're talking about the Indautor and INPI to merge. Nevertheless, there hasn't been any conversations. First, because it's not really or wasn't really convenient. And second, because there hasn't been a structure to merge the institutions.
Lo único que hemos podido realizar para exenciones de pago,
We're only able to do for fee exemption was to
con discapacidad visual,
exempt the ISBN for persons that are visually impaired. Let's follow to the Q&A session. There will only be time to answer one.
La pregunta la colega Raquel Romo. ¿Se deben
Okay, Raquel Ramos is asking, are work contracts that include the copyright clause? Can you please repeat it? Can the work information needs to be registered? Yes, there's a specific section in the copyright where you have to register individual work contracts, or Article 83 and 85. Yet you have to register the contracts. Okay, let's read another question. That's really interesting. Do we need to register all of the contracts? Or contract, addition, contract? Yes. All of the contracts that have a transmission of patrimonial rights and a licensing exclusive, yes, they do need to register. That is my recommendation. Those that have transfer of rights, individual work contracts, and exclusive licenses. Okay, thank you for clarifying. Thank you, Attorney Alquicira, for being here with us and for clarifying that information. Okay, we have a 2-minute break for our next presentation. Thank you. Thank you to everyone.
Welcome back, colleagues. Openciencia is pleased with you for staying here in this conference called Issues in Open Access Publishing 2022. Just like we mentioned earlier, Openciencia continuously carries out international events where we invite experts to share their knowledge and experience with researchers, students, professors, and editorial teams. One of our goals is to train editorial teams, improving the editorial work. In turn, this increases the quality of the research products that are being published. In this year's event, we are addressing some of the issues related to copyright and licensing that we have seen in academic journals in Latin America. Our next presentation is going to be in Spanish, so please select the correct interpreting language on Zoom. Likewise, you can write during the presentation your questions in the chat section. Please remember that we require you to write down your questions in your native language, and we're going to be translating the questions to the speakers during the Q&A section. Copyright and licensing are essential both to protect the academic work and to have the control on how it is used. Nevertheless, the legislation related to copyright can change in every country. Similarly, the registry of the works can also be different. In Guatemala, the legislation related to copyright has certain peculiarities, just the same as the registry of the work. Our last speaker in this conference is attorney Silvia Garcia from the Intellectual Property Registry in Guatemala. We are very pleased that specialized lawyers in intellectual property from the Intellectual Property Registry can collaborate in these events that we organize. Attorney Silvia Garcia is going to be presenting the topic title, Copyright Public Registry and Related Rights in the Intellectual Property Registry in Guatemala. One of our colleagues in Ecuador, Carla Flores, has prepared a video introducing our colleague. Good morning, colleagues. It is a pleasure to have you here, colleagues from different countries, in this event called Issues in Open Access, published in 2022. The U.S. Copyright Office stated that in the United States, the copyright law gives automatic protection to the work when the author has created in a tangible way. Similarly, the copyright law and related rights in Guatemala, 1998, and the Copyright Federal Law, 1996, specify that this protection is given in Guatemala and in Mexico, once the work is fixed in a tangible way in any medium. Nevertheless, the U.S. Copyright Office, the Copyright Law and Related Rights in Guatemala, 1998, and the Copyright Federal Law in Mexico, 1996, stated that the registry of the work is voluntary and the exercise of the copyright does not depend on the registry of the work in the appointed offices. Even if this is not mandatory, there are certain advantages of registering the work. In order for us to get to know these advantages, we have invited attorney Silvia Leticia Garcia Hernandez. Attorney Garcia has a bachelor in social and legal sciences by the University of San Carlos in Guatemala. She has specialized in copyright and related rights. She also has a postgraduate degree in intellectual property updating, innovation, and new technologies by the University of San Carlos in Guatemala. The VR and Notary Association, a commercial law institution in Guatemala House of Intellectual Property. Likewise, she has received specialized training through different courses taught by the Worldwide Academy by the WIPO. Around 23 years ago, she became a public worker of the Intellectual Property Registry Department in the Copyright Law and Related Rights Department. In this department, she has had a long professional career. Attorney Garcia is an author of several articles and has been a speaker in different conferences on intellectual property on an international and national level. She has represented Guatemala on the WIPO, similarly in different Central American ministerial meetings on intellectual property. Nowadays, she is a coordinator of the program of the WIPO for depository libraries in state organization. Plus, Attorney Garcia has been a researcher on intellectual property, traditional knowledge, traditional cultural expressions, and resources of the indigenous communities. Please let's give a warm welcome to Attorney Garcia that today is going to be presenting us a topic called Copyright Public Registry and Related Rights in the Intellectual Property Registry in Guatemala. Good morning, Attorney Garcia. We give you a warm welcome. Well, for the Intellectual Property Registry, it's an honor to be able to collaborate with Openciencia, with sharing the information about what we do in this Intellectual Property Registry. In that, with that idea, the office was first opened in 1999 once the current legislation started. We believe that it's important to get to know the history of this protection in Guatemala in terms of the copyright law that was first seen in 1879, right? So in Guatemala, it was enacted the first law on the right of literary property. This gave a perpetuity right, just like the current legislation stated. The right of publication and reproductions of original works, just like all of these rights are regulated in the current law. And said process was made through the Public Education Ministry, right? This department issue a property certificate to the author upon their work. Similarly, we are going to be seeing these same characteristics are replicated nowadays. Then this first law on literary property was enacted, then was enacted the very first, the copyright law on literary, scientific, and artistic works. We're talking about the year 1954 with the Decree 1037 of the National Congress, which gave a protection period of 50 years after the death of the author. Nowadays, this protection is during the life of the author plus 75 years after that. Gave the exclusive right of authorizing and prohibiting the use of the work as the same as the acquisition of the authorship of just by the sake of creating the work. Similarly, these rights are regulating to the current legislation. So it is important to highlight that in most of the countries, just like Guatemala, the copyright law, it is considered a human right. This characteristic is being acknowledged by the Universal Declaration of Human Rights in 1948, where it says that every person has the right to protections of their material and moral interests that are corresponding to the production of scientific, literary, and artistic works. Because of that, in the political constitution of Guatemala, acknowledges that this copyright law as part of the human rights and in the section of individual rights. And it is important to acknowledge that it's a exclusive right that is given to the author upon the property of their work. Now let's see the current legislation that a lot of you already know, because it's the Decree 3398 of the National Congress of Guatemala, and this decree gives life to what is the intellectual property registry. In the past, we're going to see that this registry only dealt with aspects of industrial property, but since Decree 3398 changes the name, and nowadays the intellectual property registry deals with industrial property as well as copyright aspects. This legislation has been reformulated in several instances, but among the most important ones is, for instance, the one from year 2006, because the law has a reformulation because of the fair trade agreement with the United States. Another important point is that in 2003 was enforced the regulation of the copyright law and related rights through the governmental agreement 233/2003. This is actually something that we follow in order for us to get to know the different procedures in terms of what the registry does in terms of copyright within these intellectual property aspects. Now we can see that our legislation, it's these are laws that are actually are updated and adjusted to the international conventions and treaties related to this. Our legislation takes specific aspects in terms of the Rome Convention related to the protection that is given to artists, interpreters, and executors. Similarly, our legislation is standardized related to the Berna Convention, which gives protection to artistic and literary works. Similarly, it is considered that the WIPO treaty, copyright treaty, with the initials WCT, is an updating of the Berna Convention that already includes all of the aspects related to the digital work or the internet world, right? Likewise, the WIPO treaty, the Interpretation Program and Phonograms Treaty, is something more updated of the Berna Convention. In this case, similarly, aspects of copyright law are regulated in terms of the digital work or the internet world. The Phonograph Convention, which is also a convention where Guatemala takes part, gives exclusivity to the use of the phonograms, meaning CDs or any other supporter format, phonographic format. The Marrakech Treaty recently, where Guatemala recently also participated, reformulates the law and the regulations of the copyright law in terms of the access of people with disabilities or any other disability that they have to get to know the access to written works. In terms of the Beijing Treaty, this one is only signed by Guatemala. We're missing ratification, and this one gives protection to the artists, interpreters of the individual audiovisual world, meaning actors and actresses that participate in audiovisual productions. It is important to see how the evolution of the intellectual property registry has happened up until today, because the first office that was in charge of it, that was in charge of the intellectual property registry, which was which was the industrial property, and it was part of the Department of Public Works. We're talking about 1886. During this year, it's actually the mark of 136 year of this first office. And the governmental agreement of 1944 from the Office of Patent and Trademark Office was part of the Ministry of Economic Affairs and Employment. That was the name of it. And here is the protection of trademarks and different processes for this. Then, with the decree from 1956, it was divided, right? The Ministry of Employment and the now the Office of Patent and Trademark was part only of the Ministry of Economic Affairs, which is something valid nowadays. The Central American Convention of Industrial Property established that the Registry of Intellectual Property was an institution part of the Ministry of Economic Affairs. So as we can see, from 1944 up until 1973, it was part of the industrial property aspect. As I said at the beginning, the Decree 3398 is the one that transformed the registry of intellectual property, because in the past it was just the industrial property, which was only for patents and trademarks. What's the finality of the intellectual property registry? Well, this is an administrative authority where both the industrial property and copyright law grants the permission of everything that is related on intellectual property and industrial property. Today, we're only going to be dealing with copyright, because it's what matters or what is essential for this conference. What are the things that we do in this department? Where this is the 23rd anniversary, and we do three main activities that are developed in this department, which is that law establishes that it should organize and establish a registry of the copyright and related rights, and to receive the payment and to do the enrollment of the works when the authors request it. Remember that current legislation contemplates that the author of the work has the characteristics of automatic protections. There's an absence of mandatory aspects in terms of registering the work. It's just that once the author or the holder requested so, they can use these resources that the registry provides. So another one of the main activities that they do is that they have training programs to provide training to authors, to all of the holders of the rights, editors, authors, artists, interpreters, phonogram producers, overall, all of these people that are part of our country. They also have different courses and workshops established yearly or annually, where we have reached different sectors, where we share the information about copyright and all of different activities that we do in terms of copyright law. Another area or another activity that the registry is in charge of, that in this case it will mean a different conference, but it is important. So in terms of collective management, we solve different application for these kind of activities, and we also create the registry of their members, um, and we inspect and check all of these aspects. In Guatemala, this only exists in only three aspects of collective management that has to do with the musical realm. In previous years, we had received the different applications or an application for the management, collective management of the literary works, but it was only an application. So in Guatemala, we only have the collective management for musical works. Was the most works that we actually register in this department. So most of them are group collections that we can actually register as collections. So if an author or a person has has different compilations and collections, so this makes it easier, this process, not for each work but a cluster of all of his or her works. Later on we're going to see the fees for this. We have seen that some other works that we have registered was what the Mexican colleague mentioned in terms of requested works. So when an institution requests a work to be made, as the Mexican legislation established the same in Guatemala, these contracts, the law establishes that should be made by written form, and also the collaboration work. So when more than two authors collaborate, they should be made through the registry of this, because we have specific documents that we're going to be seeing later on, and the co-authorships and collective works. In the case of the collective works is when a company requests to different people upon their same management the creation of different works. As you can see in this graphic, in this image, most of the registrations that we have had during the last 5 years, but here you can only see the year 2021. Most of the registration of literary works, musical works, has a 17%. We also have software, and we also have artistic works like songs or paintings, sculptures. And we can see that the different registrations of the collective management, like I was explaining before, and audiovisual work, that even during the pandemic has up until today, which is it's another area of the registration work, registry works that we have here in this department. The process for the registration of the works is quite simple, and usually the author can do it by himself herself, because it's just completing a document that is in a digital format that you can fill it up through your computer. In the registry webpage, you fill out the information that you are requested. Among the different documents that are available is the one from the registration of the literary work, registration of computer software, of the audiovisual work, and like I was mentioning before in the previous slide. You attach an affidavit. This can be made through any lawyer or notary worker based on the Article 106 of the copyright law, which gives an idea of how you can create this affidavit. You can also attach. You also need to attach an example of the work, and then you pay the fee. In a moment, we're going to be seeing the cost or the established prices or costs, and the process takes about 10 to 20 working days. And at the end, you pay 50 quetzales or $6, is the which that you pay for the issuance of the certifications. As you can see here, like the fees or the cost of this registration. So for example, if you're going to be registering one single book or one novel or a story, you pay 200 quetzales or $26. If it's a collection, the holder or the author can register from two onwards. And for that, you pay around $39. The artistic work, you pay $26, while computer software, you pay $65. Audiovisual works, you pay, which, involve like film and TV productions, you will pay around $52. And as you can see, we can also register contracts. Usually, the department has seen that it's not something usual that people do here, just like in Mexico or in other countries. In every country, you find an office where people can go to register this kind of works. And in the case of Guatemala, the contracts, it's even more scarce than the registration or inscription of other works, also phonograms. So it's something that we don't usually do. Culturally, we don't do it here in Guatemala. Why? There's something important that the Department of the Registry provides is this training or mentors, because as we said, it is not, this registration is not mandatory. It's a registry that every work has without the necessity of the registration or any formality. But when people does not create the registration of their works, they can use these type of like identifications that we usually see in most of the foreign works, which is the rights reserved of copyright, which is like forbidden the reproduction of total or partial production of this, or like a C with inside a circle, what is established the holder of the rights and the year where this work was disseminated or published. The regulation said the Article 24 of the copyright law says that they should be visible in the work. And in any case, its omission will miss the loss of the rights or the limitations of their exercise. So this is an identification simply when the author considers it appropriate. Through the 23 years that this copyright department has been working, we have improved with the signing of different agreements, cooperation agreements. We have an agreement with the Indautor in Mexico, where we There's an exchange of information. We also have other agreements with other type of identities or departments that have supporters and collaborated with us and help us with dissemination programs, with training programs to different uh, sectors of the authors. It's a consultative body on the matter of different entities of the public administrations. For example, the public ministry, where you can consult of the different registrations that are in charge of that department. Another role that this department has is to promote the intellectual creativity and the cultural heritage of the country. In this case, we have later on, I'll show you a little bit more, but we have promoted the creativity. We know that this registry, this department, is not very well known. Nevertheless, with the support of different bodies and different agreements that we have signed, we have improved in this area. Here you can see the different training programs that we have carried out. We focus mainly on childhood through different material with games, which is my first work, my first registration. We have given training to different holders of the copyrights, meaning all writers, editors, artists. All of these group of artists, we have provided training on the content that the law establishes and the international treaties regarding with the protection of copyright, and the different users of the registry, meaning lawyers, notary workers, university students, different universities in the country. We had taught different seminars and workshops. We have also participated in different exhibitions, como Filmwa, that we have during a few years. We have presented in these type of exhibitions of fairs to disseminate the information that we do here about what we do here in this department. We have improved in terms that the copyright law is part of the public politic on reading a book, also from the curriculum secondary education, and nowadays is still included in the National Strategy of Intellectual Property. This had guided us and allow us to improve into the dissemination and to spread the information about the copyright law. Finally, to tell you that as I was mentioning previously, that in Guatemala we have the collective management associations. We have in Guatemala the Guatemala Association of Interpreters and Authors, meaning copyright and musical works. We also have the Guatemala Association of Phonogram Producers Industry. This represents the different producers of phonograms and the artists of musical and audiovisual work society. All of this will imply another presentation. Nevertheless, it is important to tell you that in other countries, for instance, Mexico, there are different entities, management entity that represents the editors and the writers. So, for instance, Centro, I think it's called, and the one that manages that is Cedro from Spain. There are also these type of entities or departments in Costa Rica and Panama, where, like I said before, each of the holders they have this collective management so they can manage their own rights through these regulations to different clauses, special clauses to the protections of the different works protected by the copyright law. This is it for my presentation. So please, if you have any questions or doubt or a question, please let me know. Thank you for the invitation to participate in this. Thank you, Attorney Garcia. So our first question is in terms of the registration of the contracts. What happens if these contracts are not registered before the registry? So for instance, a contract between the editorial entity and the author. What happens if, for example, they do not create the registration of this contract and, for instance, and goes against the copyright law? Yes, like I said, the registration is not mandatory. So this is something that you do voluntarily. And if you do the registrations or not, like a contract, for instance, an editing contract, so then there are other entities. So, for instance, the public ministry or the justice departments where you should present the contract in case of a breach of contract. So the first consultation that the public ministry does to any judge is to check if that contract is registered in our department. So like I was saying, it's not something that we usually do here in Guatemala. It will be very interesting to see that people actually go to our department, to that registry, so they can register these contracts. Something important is that the law establishes that the first should be registered the work, so then they can adjust the regulations. So for instance, if it's a collection of stories, for example, in the contract it should be mentioned that those works were registered in the intellectual property registry. So then there is an editor that practically commits to exercise the rights of the rights, just like our Mexican colleague was mentioning. It was an agreement between both parties. The Guatemalan legislation gives us certain regulations so we can create said contract, meaning there are specific regulations to create these kind of contracts, and the law includes this. The editing contract includes the editing contract. Yes, thank you for your answer. So then, for instance, if a editorial entity wants to register the journal, it will be a collective registry among them, right? Among the registry. Well, this happens. This doesn't happen frequently, but for instance, if a Guatemalan editorial wants to register their collections, so first they should fill out the application or the document for the registration of contracts, and in that application they should attach the affidavit through the legal representative of this journal. And then it is important to know that there is an agreement between the author and the editor, where the author transfers the editor his or her rights of reproductions on the first place, or of the communication to the public. So then, with the application for the registrations, the affidavit, and in the work itself, then the editor will not be paying $26 for each of the productions, but $39 for all of the collections, for all of the elements in the collections, in the collection. Yes, so we a collection. So, for instance, with the publications or with journals, they will have to do with each number that this journal publishes, and all of the articles within that number will have to go through this same procedure. Or is it different? No. So, for examples, journal publications or articles in a journal, if it's a Openciencia journal, so then Openciencia will be registering the different articles included in their journals. And like I was saying, there should be an authorization from the researcher to where Openciencia has the holder of the patrimonial rights, meaning reproductions or anything similar. It will be part of the requirements established by the same application. And Openciencia will be able to register all of the articles through to the collection mode and paying around $39. As I understand, the registration or the registry also registers the different licenses that are inside the contracts. Or is it different with the licenses in this case? No. For each type of registration, a license has the same characteristics as an agreement or a contract. We don't have an application to register only licenses, but what we do is through the contract between the both parties, because the difference with a license is that it's just for a limited period of time, for a limited right that is granting, that the author is granting in terms of the use of said articles. That's what is being, that is called licensing. But the formality of the registry falls within the, or like the application for this is with the contracts. Yes, thank you very much for your answer. It's quite clear. So then, yes, because just like you mentioned, if a license is actually a contract, but it's an agreement, on an international level, it's very common to have among these or inside these contracts of copyright contracts and licensing contracts, this part of the license within these contracts. Because I had heard from some of your colleagues that I had talked to that you will pay, that the registry will pay for the licenses, and they had certain statistics in terms of the payments. And I was asking this because a lot of the journals are part of the open access movement. It will be interesting to see how these open licenses, if they are actually present in these countries. I understand that registering these contracts is not part of your, is not very common in your culture, but it's important to give these recommendations to editors on how to proceed with these aspects, because they don't know a lot of these legal topics and related with these agreements and contracts and that they should have, and especially to understand how this process happens within inside the registry. I will imagine that you have different activities, like different from Indantor. Maybe they have more but you actually talk about a central point of these contracts and works, and it's important when this law is not followed correctly, and how we can solve these problems. And I'm sure that you also have these um, legal advisors that can help you out with the creation of these contracts, because this is something important. I think that the difficult part is to find specialized lawyers in intellectual property that can help you out with editors, and among them is you, that can actually give very good advices and recommendations to create these contracts and to see if there's something missing. I'm sure that it's not just you, the one that is part of the legal team, right? I'm sure that you have other colleagues that have experience on this area. Yes, our department is is integrated for our the attorney Ingrid Rivera. We also have in charge attorney Marco Moreira. The head of this department is attorney Gabriela Martinez, and some others like me that are professionals, specialists in certain areas. And for us, it's going to be a pleasure to be able to help you out and to tell you that just like in Mexico, you have these procesos de evidencia. Our registry, with the help with WIPO, is making a lot of efforts to establish a mediating center. What does this mean? Well, when we have differences in a case where both parties don't want to be in front of the public ministry, or we can have a first encounter or a conciliation phase among both parties, because in terms of industrial property, this is not established. But in the copyright law, it is established that there can be a conciliation among both parties. But right now, we are making a lot of effort, and we're working to have this uh, uh, mediation center, just like our colleague from Mexico mentioned. Over there, they have avenencia procedures. In Guatemala, this is something very scarce, and this idea of registration is very scarce. To these kind of services that can be used, and any person, as I explained before, there are lawyers that they actually only focus on industrial property, but there are some others that specialize to matters regarding the copyright law. So as I was saying, it will be a pleasure for us to help you out and give you any advices and tips about this. Well, thank you, Attorney Garcia. Now let's check some other questions and comments. Attorney Quisira, when you were mentioning the institutions, this institution in Mexico will be SEMPRO and SCHEM. Is there any other question? Yes. Let's give a little bit more time for the questions. They say thank you to you. Well, just overall, this event has been an improvement precisely for us to give more information to editorial teams in terms of copyright and how they can solve certain problems and to take them into the right direction. In order for us to have everything according to the law, I understand there are some other things that can be improved. But while this will take some time, and I believe that what is important is to be aware of these issues so we can start addressing them as soon as possible so we can solve these problems on a short and long term. So then we're going to finish with this event. If there are no more questions, we thank you for you staying here in this event and to be for you to be patient. I know we had some technical difficulties, of course, with the interpreting. We hope that in our next event we won't have these kind of problems, but we're always happy to have speakers from international relevance with these elements that will have editorial teams, so you can get to know more about what we're doing in the academic publishing. And we hope that your work can be improved, from today onwards, so you can take notes of these problems in case if you have them, that you can take note of these problems and the possible solutions to long and medium term, so you can have everything accordingly, and that your journal has these standards that are very important, not just to be but to actually help the dissemination of information, and that they can follow quality standards that are important for us to fulfill, and for the good dissemination of knowledge, and not to have these problems that in the future can represent issues for the journal, and to avoid them. Well, thank you, everyone, and we're going to be here checking any questions and doubts. We are available for it. We're available to answer all of your questions. You can write to us to our email, haguilera@openciencia.com, or at openciencia.com, and we're going to be there checking any questions and doubts, and to see how we can help you out in whatever you need. So thank you, and we'll see you next time. Good afternoon.